Welcome to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate an engaged, stable, and inclusive workforce. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every employer's mind: how will my business be impacted? Since taking office, President Trump has made significant changes at federal agencies affecting workplace regulations. In addition to appointing new leadership, President Trump swiftly removed sitting commissioners of the EEOC and NLRB, limiting a number of key agency operations. On this episode of We Get Work, we explain the seismic shifts that have taken place in the last month and discuss what employers can anticipate from these agencies now and in the near future. Our hosts today are Michael Thomas, co-leader of the Corporate Diversity Counseling Group, and Mark Tilkens, a core member of the Labor Relations Group and principals, respectively, in Jackson Lewis's Orange County and Dallas offices. Michael and Mark, the question on everyone's mind today is: how will changes at the EEOC, NLRB, and other key administrative agencies affect employers, and how does that impact my business?
Thanks, Alicia. The start of the Trump administration has really brought significant changes to many areas of employment law, including to federal agencies, and the National Labor Relations Board and the Equal Employment Opportunity Commission are no exceptions. And so some moves have been anticipated, but others were not. Some moves have occurred before, so in the past. So there's at least some precedent, and some moves are just really unprecedented. So we're here to discuss some of the current changes to the NLRB and the EEOC and what you can do as an employer to make sure that you're being proactive. And so my name is Michael Thomas. I'm a principal in our Irvine, California office. I'm also co-chair of our National Diversity Consulting practice. And I'm here with my good friend and colleague, Mark Tilkens, who I'll let introduce himself.
Thank you, Michael. It's great to be here. My name's Mark Tilkens. I'm a principal in the Dallas, Texas office. I've played, at least for the last decade, a primary role in our labor relations practice group. And union relationships, the approach to handling employee relations, and the effect of that, all of that federally protected activity on the part of employees is a primary focus of mine.
Yep. Excellent, Mark. And so let's just jump right into it. And I know our audience is pretty broad. Some people are familiar with NLRB and some people may not be. So, Mark, what is the NLRB and really what's within its jurisdiction?
This is an important one for employers who don't have a represented workforce with no union in there. And oftentimes that's something that's misunderstood. The National Labor Relations Board, or as we call it, the NLRB, is an independent agency of the federal government. And it was created in 1935 by Congress in connection with enforcing the brand new National Labor Relations Act, which was a remedial law passed at that time. The NLRB ensures that employees have the right to organize, the right to engage in collective bargaining through a representative of their choosing. Most of the time, that's a traditional union, but at times it becomes new and or employee-created unions. And the NLRB is also responsible for making sure that employees have the right to refrain from such activities. The job of the NLRB historically has been to supervise elections, representation elections, as well as investigating and remedying unfair labor practices. It's governed and commissioned with a 5-person board and a general counsel. And all of those individuals, the 5 members, as well as the general counsel, those are positions that are appointed by the President of the United States with Senate approval.
Thanks, Mark. That's very, very helpful. And so what are some recent changes at the NLRB?
Well, these are not boring times, but understand that the NLRB is an agency, unlike many parts of the federal government, that historically is one of the most volatile. So over the course of the last 90 years, the National Labor Relations Board has undergone incredible swings in the doctrine and the effect and meaning of the National Labor Relations Act for employers. And that's because they have an incredible amount of regulatory and administrative authority. And that was the intent of Congress. So unlike other agencies that often fall under some scrutiny as of late with regard to the freedom or latitude that they've taken in connection with how they administer or interpret laws, The National Labor Relations Board is actually one that has never been boring. And these days, it's even less boring than it has been in the past. So what we've seen lately is we've seen an expected termination of General Counsel Jennifer Abruzzo. And I say expected because for the first time in history, it was unprecedented when President Biden terminated the previous General Counsel. Normally, they were allowed to continue their term. There was litigation that followed that termination, and the litigation was unsuccessful. And so everyone who was paying attention to the change in administration expected Jennifer Abruzzo to be terminated, and indeed President Trump did so. What was not expected was the termination of board member Quinn Wilcox. This was a first. We had not experienced in the history of the National Labor Relations Board a termination of a sitting and Senate-approved member of the National Labor Relations Board. And because of that change, we expect further litigation. We don't know at this point whether the litigation that she's planning to file and has already announced publicly is going to proceed with. We don't know whether that will be successful, but what we do know is whether or not that's successful, the board has been deprived of a quorum. And this is the second time that we have had that happen. Happened during President Obama's presidency. We were without a quorum in connection with the inappropriate appointing of members, and a number of decisions had to be relitigated or reapproved by the ultimately properly appointed board. And so it's not entirely uncharted waters, but it is in that we have not seen the termination of a board member before. And then finally, we are experiencing significant change. It was expected, but the acting general counsel, William Cowan, had rescinded a series of guidance memos that laid out the vision from general counsel Jennifer Abruzzo, where she laid out her vision for the board. Those were all rescinded. And in there was a number of prosecutorial initiatives, policy objectives, and those have all been withdrawn. And we expect there'll be further guidance coming from the new general counsel, and it will look in many regards similar to what we saw during the previous Trump presidency.
Yeah, no, it sounds like there's a lot of change going on at the NLRB, and especially at a time when there is a rise or an increase in unionization, in some ways easier for employees to form a union, and we don't have quorum, at the NLRB. So, how do you think these changes will impact employers?
I think that there's two things to think about here. One is what will change and what will not change. I'll start with what things are not going to change in connection with no quorum. Employers will not see a paralyzing of the regional offices that are responsible for investigating unfair labor practice charges against employers. And the employers will not see inability for the regional offices to process election petitions. Those things will continue, and there isn't a need for an appeal body, that is the board. There isn't a need for a quorum for those administrative day-to-day functions of the regional offices. And we will continue to see the board, at least at the very early stages of a board action, we'll see the board through the regional offices continuing to do business as employers had. Now, that has been slowed because there's such a backlog of cases waiting for trial over the last 2 to 3 years, but we will continue to see it. So that's what's not going to change. What will change immediately for employers is there isn't going to be any appeals that are issued in connection with those decisions that have been appealed up to the full board, because we don't have a full board. So we're not going to see anything that is coming out of the NLRB. We're also not going to have resolution regarding the litigation over the termination of board member Wilcox anytime soon. Litigation through the courts is notoriously slow. It will be here. And this was by design. This was intended to paralyze the NLRB. And I think that for employers, one of the things that they have to take away from this is that the impact on them should not be viewed as something that changes their employee relations, their labor relations, and their moral compass with regard to the workplace environment they create for employees. It should be something that is going on and is viewed mostly as noise, because if they violate labor law, the regional offices will continue to demand investigations. There'll be continued demand of documentation, and they will be held to account for those decisions. So this is not the Wild West for employers if they're doing things correctly.
Yeah. Well, and so with that in mind, so what should employers do to prepare for these changes and potential changes that could be coming down the road that may or may not be expected?
I think that there's There's a few main things employers should take away from this, and they should understand that chaos is very contagious. And for the last 4 to 5 years in particular, but certainly beyond that, it has been a very significant period of turmoil and change in the workplace for employees. And chaos is very contagious, but calm is equally contagious. So, in this era of uncertainty from the National Labor Relations Board, employers have to recognize that it's important for them not to contribute to the volatile swings that we're seeing across the doctrine from the NLRB and that we're likely to see throughout the remainder of the Trump presidency. As a takeaway from that, employers should significantly look at the issue of smart risk differently than they have in the past. So most of the time in the past, the volatile changes from the National Labor Relations Board have been things that have been evaluated by labor relations or lower level HR people. And they've made decisions about these issues because they had some prior experience with them during previous administrations or in a previous employment life or with a union. They have more knowledge about this area than many of the people they report to because it is a very niche area, including C-suite folks. And so they would make those risk calculations in a vacuum. They would recommend policy changes. They would make decisions in connection with input of information on termination or disciplinary decisions. And those siloed risk assessments are dangerous. This is a time for employers with an ever-changing NLRB. This is time for them to evaluate in what we like to call smart risk analysis. Advise C-suites, advise the HR leadership, advise management leadership of what the changes mean, what the pros and cons are of them, and make a fully informed risk decision because it's terribly unpopular for an HR person or a labor relations person to be having to answer questions when one of those leaders was surprised by some board charge or action and asking, why was I not informed that you made a change with regard to how we were going to administer our policies or our practices? And I think that's true for a lot of areas of the law, but it's one that's been a gap for employers on the labor side for a while. And this is an area that we strongly recommend that they do a little better job of educating those internal stakeholders and making a fully informed smart risk decision.
I like that. Thanks, Mark. It's really helpful that, sometimes staying calm versus being reactionary is the better approach.
Yeah, thank you. Well, I'd love to ask you a few questions about areas that you know much better than I do, if we can transition to that now. I have been listening and paying attention to all of the authors that are writing on the topic of DEI, and it's been a hot topic and in the news a lot lately in light of all the executive orders and changes to the EEOC. And I'd really love to hear from you, Michael. What is the EEOC? If you could just back up for many of our listeners and what's within their jurisdiction, I think that'd be a great starting point.
Yeah, thanks, Mark. And so just generally, so the EEOC, Equal Employment Opportunity Commission, is really charged with enforcing and also setting the policy agenda for enforcing federal anti-discrimination laws. So that's both the enforcement and setting the agenda, which becomes important. And I'll talk about that a little bit later. But just like the NLRB, the EEOC is bipartisan. The EEOC has 5 commissioners appointed by the president and confirmed by the Senate. So there's a chair, vice chair, and 1 commissioner are members of the majority party. So that's 3 of the 5, while the 2 commissioners are members of the minority party. And so it is a bipartisan agency, which becomes important. The 5-member bipartisan agency, they approve policy agendas, they approve most of the litigation, and they make decisions regarding policy issues, litigation recommendations, federal sector appellate cases as well, amicus curiae briefs, and subpoena. So, the EEOC is a pretty active agency, Mark.
Thank you so much for that helpful background. What are some of the changes that are occurring right now that I've been reading about and seeing some headlines, even if I didn't have time to dig into those articles? What's going on out there?
Yeah, well, I'll try to keep it short. But, we have a new administration. And as you mentioned, Mark, this new administration is moving very quickly with a whole bunch of different agencies and making a lot of change within a short period of time. Some things are expected, some things are unexpected. So what is expected? What was expected is on January 21st, Commissioner Andrea Lucas was named acting chair. And so acting chair Lucas was appointed by Trump during his first administration. So she's now the acting chair. Also, as expected, on January 27th, President Trump fired General Counsel Carla Gilbride. And also that same day, an unexpected move or really unanticipated move, President Trump removed Commissioners Charlotte Burrows and Jocelyn Samuels. And that ended a Democratic commission majority that we actually had expected to exist until 2026. And so now only acting Chair Lucas and Commissioner Kodegal remain. And so similar to the NLRB, the EEOC does not have quorum. The EEOC only has two members. And I'll come back to that in a little bit to discuss really more what that kind of means. The other thing that President Trump did was on February 4th, named Andrew B. Rogers as acting general counsel. And in some ways, it's not that surprising. Mr. Rogers previously served as chief counsel to Chair Lucas, so there's some familiarity there. And then in an agency press release on January 28th, Chair Lucas set forth the policies that she believes that she intends to implement, within her power now that she's chairing the agency once approved by the Senate. And what she laid out was that she understands our nation's civil rights laws reject identity politics and instead focus on individual rights and equality. She prioritizes even-handed enforcement of civil rights laws for all Americans, including by rooting out unlawful DEI motivated by race and sex discrimination. She focused on protecting American workers from anti-American national origin discrimination, defending the biological and binary reality of sex and related rights, including women's rights to single-sex spaces. She's going to focus on protecting workers from religious bias and harassment, and also remedying other areas that have been historically under-enforced by the agency, and that's somewhat undefined. And so the statement that was released on the EEO website, the statement is very much aligned with the president's recent executive orders regarding illegal DEI and also regarding gender. And we've seen the EEOC recently take some steps to really enforce that newer policy agenda that's aligned with some of the president's executive orders. And what I mean by that is most recently, the EEOC actually moved to dismiss 6 of its own cases on behalf of workers alleging gender identity discrimination. And in dismissing those cases, they argue that the cases now that there's a new administration and a new EEOC, they now conflict with President Trump's recent executive orders. So these are some of the changes that we're going to see, with the new composition of the EEOC.
Yeah, that's a lot of change. Thank you, Michael. How are those changes going to impact employers?
So in general, the EEOC approach to litigation and even policy direction might be starkly different than what it's been in the past. And so, as I mentioned, they recently withdrew cases involving gender identity. But just last year, the EEOC actually updated its guidance to specifically and deliberately state that using the wrong pronoun for an employee or refusing them access to bathrooms corresponding to their gender identity constituted a form of harassment. And that's now a direct reversal, really just 1 year later. And that followed the Supreme Court's 2020 decision in Bostick, ruling that gay, lesbian, and transgender people are protected from employment discrimination. So now that the focus is very different. And so that's one example that employers might see where the EEOC's focus is starkly different than it's been in the past. And so similar to the NLRB, like without quorum, there are some changes that are not likely because they cannot occur. So without quorum, they're not going to be able to revoke old guidance nor institute new guidance. They're not going to be able to revise or implement regulations, and you should still comply with the EEO1 requirements. It's going to be a challenge for them to make any changes to those. There's also going to be an impact on litigation. Again, I mentioned the focus might be a little bit different. Also without quorum, there's no current mechanism for the commission to approve pattern or practice or systemic cases. So that type of litigation, there's no quorum to approve that. We're going to see a greater focus, again, on the policy agenda laid out by acting Chair Lucas. And again, some of that will focus on what the Trump administration refers to as illegal DEI. Litigation that's already pending is likely to continue. But again, we saw this recently with the 6 cases that were on gender identity that they moved to dismiss. There could be additional cases that acting General Counsel Rogers may choose to actually not pursue. And finally, there could be an impact on both charges and also subpoenas as well. So a lot for employers to keep in mind.
Yeah, that's super helpful, Michael. Thank you. If we transition and reflect on all those impacts from a prep or a best practices standpoint, what are we recommending and what do you suggest employers do to prepare for all those changes and those impacts?
Yeah, in some ways, similar to what you were saying with NLRB, Mark. And so although this remains a fast-changing environment, existing EEOC litigation and charge investigations are likely to proceed as usual. The exception is that it's going to have a different focus. The focus will be more on the policies that I mentioned earlier. So employers need to still take steps to comply. Employers need to still take steps to identify what are practical solutions to mitigate the risk of charges, the risk of litigation. Employers might want to take a step back and reevaluate some of their strategies in cases now that the focus of the administration or the EEOC is a little bit different. That might cause a rethinking of your strategy. But again, employers need to just conduct privilege investigations, privilege DEI assessments, and review their current policies and handbooks for anything that might fall within the purview of the EEOC's kind of new focus or new agenda.
Thanks very much, Michael. This really remains a fast-changing environment, and there are some things that we really want to re-emphasize have not changed, and that is specifically employers should comply with the law. They should consider practical solutions to mitigate the risk of any changes that come from the government, and that includes states too. And they should reduce litigation with an eye towards being the rock of stability in the lives of their employees while they're on the receiving end in a very tech-heavy environment of continued news stories, all designed to generate a click. And we're here to help you, and we're very thankful for that. So, Michael, thank you for the great conversation today, and thank you, everyone, for listening. It's been our pleasure.
Thanks, everyone.
Thank you for joining us on We Get Work. Please tune in to our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on Apple Podcasts, Libsyn, SoundCloud, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.